to move a petition relating to selection and appointment of teachers, my lord. Selection has been illegally conducted, my lord. And that we are challenging, and there is.
I think for motion you have to move the other bench, senior bench.
We have seen the notification that the selection matters of teachers is to be taken up by this court.
Is it just a moment?
Notification says like that.
Just a moment. Oh no, I think you see, from 2020 onwards is the bench of honorable justice Manas Ranjan Pathak. For me, the allotted matters are up to the year 2019. So it has been bifurcated. You are right, but
we have to move there.
yes, please.
Wait, please,
Yes.
I beg to mention item number 15, my lord. In this matter, my lord, my service has been regularized, my lord. So in terms of my joining letter, my lord, the matter may be closed. My lord. Item number 15.
Just a moment. Okay. Also, duly represented. Upon instruction, Mr. Aram Dekar, counsel for the petitioner, submits that the petitioner has joined service pursuant to the appointment letter. It should be
Regularized, my lord. My service has been
the service has been regularized pursuant to the order passed by
passed by the director, my lord, on 5/8/2019, my lord.
Director
Director of Higher Education.
Higher Division on
5/8/2019.
5/8/2019, and accordingly, he has instructions not to press the matter. Matter stands closed on satisfaction.
I am obliged.
Any interim order is operating?
No, my lord, there was no interim.
Okay. Yes.
Well, I beg to mention item number 40, my lord. We have filed a contempt petition, my lord, for non-release of pensionary benefits, my lord. So, lordship, in the meantime, we received all pension benefits.
Okay. Upon instructions, Mr. J.N.U.M. Laskar submits that the pensionary benefits for which this contempt petition was filed has since been paid. Accordingly, he has instructions not to press the matter. The matter stands dismissed on satisfaction. The respondents are represented.
Can I please, Your Lordship?
Yes.
Lordship, I beg to mention item number 24, Lordship. My senior Lordship, this already is having some difficulties, Lordship, today. Item maybe H1 for a week.
List after 2 weeks has paid for by land counsel for the petitioner. Okay.
You see, my lordship. My lordship, with the consent of the other side, I beg to mention item number 50 and 51 of the daily list, my lordship. My lordship, my senior is out of station. So kindly pass this matter for a day.
You have taken consent of the other side,
Yes, my lordship.
50 and 51.
Yes, my lordship.
Okay, with consent of the other side, Miss
AMSN, my lordship.
AMSN, MEACN, counsel for the petitioner, pays for adjournment, pays allowed, list after 2 weeks.
My lordship, can it be on Friday?
No. Because every day matters are
My
postponed.
lordship. Oblige, my lordship.
Yes.
Daily list item number 1244 delivery of items.
1 to 4, the delivery orders is being postponed because of that item which is fixed today,
Lordship,
item
that-
60,
16, Lordship,
part 2.
yes,
After that, immediately the order is ready, immediately on that,
yes, Lordship.
it will be delivered.
Oh, Lordship.
Okay, so I see if the matter is being taken up today, then. You may not be here, Mr. Nath, I'll record your presence.
5 and 6.
Yes. In 5 and 6, both the matters are dismissed. Orders will get it shortly on that.
Obliged.
Item number 7 for motion.
Just a moment, I'm just releasing you those orders, bill orders. Hello, Devo.
Item number 7.
This is Lordship second bail application, Lordship. First order, your Lordship will find page 34. 3 persons approached before this honorable court that was rejected, Lordship. And
Please,
subsequent
just a moment.
page 34.
Listing it on Friday along with the records of the other bill case, so that PP can address us.
Lordship.
There's this matter. Along with. The records of BA 2287 of 2022. Disposed of by order dated 29/9/2022, where the scanned copy of the case diary is available.
Lordship, kindly see page 45, Lordship. There was direction to the registry regarding records, Lordship. Page 45. Serial number 10. So probably that record is in connection with now, bail application number 129.
Page 45.
Yes, Lordship. This order starts from page 42.
Okay. Records of BA 1298 of 2023. Both, we don't know where it is lying. BA 2287 of 2022 and. We are listing with both. We don't know where it will be lying.
Lordship.
It may so happen that there is a mistake on the both the actions. 1298 of 23 and.
Page 34 and 42. Lordship.
And 2287 of 22. Okay.
All right.
Item number 2, dismissal of party. Item number 8,
This none appears on call for it. Oh, you are there.
Here we have
Okay.
with the new incumbents, Lordship, into the earlier incumbents. The
Okay.
independence of the should matter. All income has been
Mr.
changed. my lord.
MU Ahmed Lam, the counsel for the petitioner, has moved this interlocutory application for impleading the present incumbents to the
Okay, that's one number 70 to 24, my lord.
to various officers as respondent numbers
17 to 24
17 to 24.
in case of the earlier.
It is submitted that the present, the parties sought to be implemented had been put to notice. Where is your notice?
So let's see, that is in case 41, let's see.
No, 41 is
Sorry. 31. let's see.
31. Let's put the notice. While lawyer's notice dated 28 to 2023 to comply with the orders of this court. So the postal receipts in respect of this notice issued are also annexed to this application. In view of the non-compliance of the orders of this court, for which the connected contempt petition has been filed, this interlocutory application stands allowed by pleading the opposite parties number 70 to 24 as respondent numbers 17 to 24 in the connected contempt petition. The contempt petition is heard so and so. In view of order passed today in IA Civil 1150/2023, the registry shall implead the opposite parties number as 17 to 24 as respondent numbers 17 to 24 in this contempt petition. Next paragraph. Pending correction of the cause title by the registry, issue notice returnable, issue notice to the newly implemented respondent numbers 17 to 24 by registered post with AD. Steps within a week from today. The notice is made returnable on after 5 weeks give a date. Stop. Next, the learned counsel for the petitioner is permitted to submit the postal track report in respect of the notices issued. List on
22/5.
That's it.
22/5.
Data part, let's say I have any problem, my lord, so far. Responder one, BGS or the commissioner, my lord, I have had. It will change now after filing this. I'm not sure, let's say, to.
file an application. So far as they are concerned, I have issued notice. Okay.
Like,
Item number 9. For a concern.
Oh, just add one line. The pendency of this contempt petition shall not be a bar for the respondent authorities to comply with the order of this court. Yes,
In this way, the petitioner to take instruction from their client members,
okay.
from school, so petitioner is not present here.
No, in the meantime, you also try to get the instructions and put it on record. Because you see,
Our Mujumdar is today out of station.
no, it's okay, but there must be some document on record. Bring it on record, whatever documents are there. None appears on call for the petitioner. Mr. U. Sharma, and standing counsel for the secondary education department has referred to the order dated 11/4/2023. Be there as it may, the petitioner remains unpresent. The matters stands adjourned for ends of justice. List after 2 weeks. Next, in the meanwhile, the standing counsel for the secondary education department is also at liberty to bring on record instructions received by them.
And may I please, Lordship?
Yes, where is BTC counsel?
Lordship, in this case, BTC file affidavit, Lordship, has file affidavit. So we have to take instruction from the petitioner whether he will file the reply or not.
Okay,
Lordship, 2 weeks time may be given.
I'm appearing on behalf of Rita Bordu,
Okay.
RB.
both sides are duly represented. The learned counsel for the petitioner, raised foreign is granted 2 weeks time to obtain instructions in respect of the affidavit
Reply, Lordship.
in opposition filed by the BTC.
Much obliged.
Deeply obliged.
Eleven.
So earlier, okay, the lordship, please ask my lord, them to confirm my lord whether they have filed a affidavit or not, my lord. So far,
Yes,
we have filed a reply, my lord.
yes, Mr. Sharma.
It is elementary, madam.
Oh, elementary education.
Yes.
Nobody is there?
What is the lordship on 8/6/18, my lord? Learned court granted 3 weeks time to file education department file 18 opposition, my lord.
Okay,
On 18/7, my lord, they have filed a comprehensive affidavit and asked them to serve the copy on us during the course of the day. And accordingly filed a reply, my lord. That is in the record, lordship. 18/7, 16/8 and 8/6.
your affidavit in replies, file pursuant to affidavit in opposition filed on,
Lordship,
affidavit in opposition filed on.
filed on.
29, 29/10/2018.
Yes, that's it.
Affidavit in opposition lordship filed on 16/8/2018. And we filed reply on 16/8.
16/8/2018.
We filed reply on 29/10/2018.
Whether it was filed before a registry or not, lordship, lordship was pleased to ask them to
Okay.
confirm whether a certain, my lord, whether it was filed before a registry. or-
Here, Ahmed Lawan, counsel for the petitioner is present. None appears for the elementary education department.
My lord.
You are there?
My lord, our motion not appeared.
No, that is okay, but you have filed your affidavit or not, that you are not saying. Your name? Mr. G. Pegul, learned counsel for the elementary education department is present. Mr. He has no instructions as to whether any affidavit in opposition as served to the learned counsel for the petitioner on 16/8/2018 has been filed or not. Nonetheless, the affidavit in reply filed by the petitioner is on record. Next. On the next date, the matter will be heard on the basis of materials available on record. We'll fix on next Monday. 15/5.
Well,
Same lordship, 12, 13 and 14.
12, 13, 14, same.
Same.
Okay, same order.
God bless you.
16.
May I please as your lordship?
Yes,
My lord, in this matter, my lord, the respondent has taken time that they have, my lord, submitted before my lordship that some of the petitioner has been accommodated as a tutors. And my lordship wanted to know that the who had been accommodated and who are left out by way of an affidavit, my lord. And but my lord, I have not received the affidavit till date, my lord.
no, this is not that case. This is
Item
3659.
My lord, the item 60.
Item 16 is 3659.
16, my lord, I have heard that item 60. I am very
No,
sorry.
no, that's
I'm very
okay.
sorry.
It's okay.
May I please your lordship?
Yes,
Lordship, this matter is infectious because the petitioner already is dead before 2 years.
he is right.
Yes.
Okay. Your name?
SK Malambi.
SK,
M Alamgir.
SKM Alamgir. Upon instructions, Mr. SKM Alamgir, then counsel for the petitioner submits that the petitioner has expired 2 years back. Mr. G. Pegul and the government, then it's standing counsel for the elementary education department is present. On death of the petitioner, the matter has become infectious. Accordingly, representation stands closed.
Hello. 17.
May it please your lordship. The lordship. Pray your lordship to kindly adjourn the matter for today, as my senior is out of station for a prior matter in the Supreme Court. Lordship may kindly explain out the dates.
Yes, you have not filed your affidavit.
My lord, we filed affidavit.
You filed
There,
when?
there is a query from this honorable court that whether post of assistant resides come under the grade 3 or not. That
Yes.
point we have placed that.
Oh, yes, it is there.
My lord.
Okay, both sides are represented. On the prayer made by land council for the petitioner. List after 2 weeks.
Alright.
18.
On the last occasion also, your lordship, petitioner did not appear.
Now the prison call for the petitioner.
Your lordship, we have taken our stand on our affidavit, your lordship.
Yes, P
Kindly.
Das, then counsel for the petitioner, sorry, for the BDC is present. The
Appearing on
petitioner,
behalf of P9.
the petitioner was absent when the matter was previously listed on 19/4/2023. When it was made clear that if the petitioner remains absent on call on the next date, adverse orders will follow. Today, as the petitioner remains absent on call, the court is inclined to presume that the petitioner is not interested to pursue the matter, and according to this, representation stands dismissed for non-persecution.
Deeply obliged.
19.
Wait, please, your lordship.
Just-
This item become infectious, my lord.
Okay. Both sides are duly represented. Upon instructions, Mr. P. Cycle and counsel for the petitioner submits that the matter has become infectious. So accordingly, this the petition stands closed, having been rendered infectious.
No.
20.
It is your lordship.
Yes,
My lord, this matter has become infectious.
okay. So your name,
Sorry.
your name,
TL Chaudhary. TL Chaudhary.
P.
TL. T for Tamil Nadu.
T L Chaudhary. Upon instructions, Mr. T L Chaudhary counsel for the petitioner submits that the matter has become infectious. Both sides are represented. According matters transferred,
Hello.
rendered infectious.
21 and 22.
Lordship, regarding 21 and 22, Lordship, timing Lordship, and Das is coming, Lordship, is Mr.
Okay,
As Das is agreeing, Lordship.
21, 22, okay,
Timing Lordship is coming.
okay, okay.
23.
Yes, Mr. Sobi, your matter. You want to have it walk over?
Oh, my lord, I'm sorry, my lord. But here in this case, my lord, the petitioner was initially he was the headmaster of a ME madrasa. And subsequently that madrasa was amalgamated into high school. And as he was amalgamated, his school was amalgamated to high school, my lord. So his post is become assistant headmaster, that is the assistant
Yes.
superintendent.
No affidavit.
My lord, instruction is required, my lord, or sometimes it's required, my lord. Yeah,
No, they will not give you 2018 matter. Why you are depriving him of his status of assistant superintendent? You transferred him to you gave him that post and then, where is this post under which act? Assistant superintendent is under which act?
My lord, there is notification, page 29, my lord. Page 29, the relevant portion, my lord, page 30, my lord, and para 7. Only on the ground, my lord, he was transferred. My lord, so far the transfer is concerned, my lord, we don't have so much obligation. Only thing is this, my lord, we have been transferred as assistant teacher, my lord. Although he is not an assistant teacher, he is an assistant headmaster.
This is under which act?
My lord, the amalgamation was taken place by this notification, my lord. The government has taken.
No, now the 2011 act is not there. What is the present act?
Present, my lord, 2017 act is there, my lord, 17. But here, my lord, so far the degree is concerned, my lord, it has been
Just a moment,
specifically
let me-
mentioned.
Just a moment. In this 2017 act, where is the cadre?
My lord, para 7 it says so, my lord.
No. That para is that is 2011 act.
Right.
Under the new act, where is this post of vice president, what do you call, assistant headmaster?
My lord, that
2017 act. Because if that office has been abolished, then we can't give you the status.
My lord, on this point, my lord, today, actually after long intervention, the matter has come, my lord.
Okay. Both sides are duly represented. The elementary education department is not,
Secondary education department.
the secondary education department is not filed. They are affidavit in opposition even after 5 years of pendency of this right petition. So accordingly, the respondents are put to notice that in the event no affidavit is filed at least 2 days prior to the next date of listing, the court would invoke the doctrine of non-traverse and proceed as and presumes that the respondents have admitted the claim of the petitioner. Next paragraph. Having noted that the petitioner has based his claim for the post of assistant headmaster of the
Kaliadinga, I mean, high school.
no, of the assistant superintendent in the school in question. Under para 7 of the OM dated 22/9/2016, which was issued under the erstwhile Assam Venture Educational Institution within bracket Provincialization of Services bracket close Act 2011. And as the said act has been repealed on the enactment of the Assam education within bracket provincialization of services of teachers and reorganization of educational institutions bracket close Act 2017. Which apparently does not have a cadre of assistant headmaster. Call the learning council for the petitioner shall address the court on the next date on the said point. Shall also list on, give a fixed date after 2 weeks.
Twenty-six, five.
I did this.
25 and 26.
Petitioner remains unrepresented. How the standing council for the BTC is present. Standing council for the secondary education department and BTC is present. For NJ Justice in Matter stands adjourned today. List after 2 weeks. At least you can produce the instruction and show us that whether the matter is live or not.
27.
You have filed an affidavit, no?
BTC is here, madam.
Elementary Education Department was to file an affidavit. None appears on call for the petitioner. You have seen that despite order dated 19/4/2023, the Elementary Education Department has not filed an affidavit. In the matter. Similarly, the BTC has also not filed their affidavit in the matter. Next, notice a motion was issued by order dated 8/10/2018. Next, accordingly, the court is inclined to invoke the doctrine of 9 towers and the matter shall be heard on the exit on the basis of materials available on record. List on, give a fixed date after 2 weeks.
29/5.
Next para, it is expected that the Learned Standing Council for the BTC as well as the Education Department shall transmit a copy of this order to their to the respondent authorities and provide a proof of such service to the court on the next date.
28.
Here, we have already filed our response, my lord.
Okay.
Lordship, they have filed the reply, Your Lordship. We received it today, Your Lordship. Your Lord, we received it today. Can we go through, my lord, can you fix a date, Your Lordship?
Okay. Both sides will be presented. Mm. The I mean, Mr. A. Fukan, Learning Counsel for the Elementary Education Department submits that he has received a copy of the affidavit in opposition, reply
Reply.
filed by the petitioner today, and he plays for some time to go. Peruse the same and obtain instructions. These are 18 matters. After 2 weeks, give a date based on
26/5.
My lord, in fact, we have filed it on 29th of April, my lord. We have, my lord, already served one copy, my lord, at the time of filing. So a short date may be given.
we are giving it after 2 weeks. Somebody has accepted it for you on the last date also. 2/5, Mainul Haq. SC Elementary Education.
From the office, must be, they have not, my lord, we have not received that.
It's okay.
My lord,
It's okay.
we go through it.
We
Keep
give it
your,
after 2 weeks.
keep your.
26/5. 29.
Okay. Both sides remain unrepresented. This is elementary. You're not appearing in the matter? You're not appearing in the matter? Okay, now there is on call for the petitioners. Respondent number 5, Mr. A. Fukan for the Elementary Education Department is present. For answer, justice, the matter stands adjourned today. List after 2 weeks. At least you can bring on record whether the matter is infectious or not. Unnecessarily, these matters are pending.
30.
At times, it gives an impression that except for the court, nobody is interested. Or at least the department is not interested. Yes, what do you have to say?
Lordship, I am appealing for the response number 7, Lordship. Lordship, kindly allow us 2 weeks time for filing affidavit in opposition, Lordship.
Okay, non-representative call for the petitioner. Mr. A. Fukan, the counsel for the Elementary Education Department is present. Counsel for the respondent number 7. Place for him is granted 2 weeks time to file affidavit in opposition in the matter. The next, as the Elementary Education Department has not filed any response. Now the court should presume shall invoke the doctrine on non-purpose and presume that the Elementary Education Department has admitted the claim of the petitioner. Next para. The learned standing also, Mr. A. Fukan, learned standing also for the Elementary Education Department shall send a downloaded copy of this order to the respondent authorities and shall produce a proof of such issuance of such notice to the court on the next date. The affidavit in opposition shall be filed by the respondent 7, that is 2 days prior to the next date of the swing. List on, give it fixed date after 2 weeks.
26/5. 31 to 33.
Next is the lordship. Lordship matters pertaining to regulation of their services, my lord. On the last occasion, my lord, respondents are directed to file their affidavit, my lord, but till date they have not filed their affidavit.
We'll presume they have admitted.
No, my lord, there earlier one affidavit has been filed, my lord, by the director, my lord. Then court has ordered to file an affidavit by the commissioner, my lord. My lord, today I am seeking some time because the file has been misplaced, my lord, unfortunately. I
No,
could
no,
not
you see
trace out-
that order was passed on 14/1/23.
my lord, in office, my lord, I could not trace out
No,
the
I
file.
understand, but you see,
And to-
here's the court order, you file an application for modification. Because otherwise, if I don't trouble you, this education department is not going to, what you call, file their affidavits. I'll put you to equal problem. The department has to suffer for it. Both sides are duly represented. Mr. S. Das, standing us for the higher education department. Pays for some more time to file, to have an affidavit filed by the commissioner secretary to the higher education department. Next problem. The court is upheld by the fact that such an order was passed by the court on 4/1/2023. Full stop. Therefore, the non-filing of wherein it was made clear that the affidavit shall be filed without fail. Full stop. Accordingly, the court expresses its anguish that the orders of the court are taken lightly. Full stop. Hence, the is provided that along that if the higher education department intends to file any affidavit, it shall be preceded by filing of an interlocutory application to explain to the court the delay for not filing such an affidavit within time. Full stop. It is noted with concern that this is a writ petition filed pending since the year 2019 and 21. So therefore, the part of the respondents is not at all appreciated. Next paragraph. The interlocutory application along with the affidavit, if any, shall be filed at least 2 days prior to the next date of the stay. Failing which, the matter would be heard on the basis of materials available on record without taking into cognizance the affidavit already filed by the higher education department on record. Next paragraph, list on after 2 weeks, give a date.
29/5.
Plus. 20.
What's up?
Fifty-nine. 59.
Mr. PK, on behalf of PK, I should put number 1 minute.
Okay, after some time. Okay.
$60.
May I please, Your Lordship?
The
of
status
basis.
is not on record. You got the information, no.
No, my lord, the information we have not been served with and no affidavit has also been filed, my lord. Lord, I have also tried to, my lord, obtain instruction from the petitioners, my lord. But, my lord, I could not get hold of all the petitioners, my lord. Now, who has been given the benefit of tutors? And who are not?
Elementary who is appearing,
Lord, R. Majumdar last time appears, my
no,
lord.
he is not absent today.
Secondary, my lord.
We'll ask your authorities to be present with the file of all the teachers who has been made tutors or what you call
Male.
teachers. I'll have to do the exercise if they don't do it. 8,000, 11,000 files will have to be brought to court.
Secondary.
Correct.
Can
No, you will not do it. The department,
after some time, Mr. Majumdar is actually appearing this matter.
it's okay, but you see, you don't assist the court. Therefore, 11,000 files you bring to the court, I will do it. Saturday and Sunday, I'll sit here and I'll look at the records. At 2 o'clock, you tell us. Otherwise, we'll file or pass an order. Within 7 days, all these files should be seized wherever they are and will be brought to the court. Saturday and Sunday, I request the Honorable the Chief Justice to allow me to work in the courtroom. I'll look at the 11,000 files if you don't have time. At 2 o'clock. 7 days time to bring all the 11,000 files to record. You tell us what to do at 2 o'clock. Small, what you call citizens who are waiting for their post of tutors, teachers, you do the exercise of screening. And then in none of the cases, the list has been brought on record. We merely go by your statement that so many people have been found as tutors there, these people have been working, these people have not been working. So there is absolutely secrecy maintained. The state cannot keep secrets in its closet. This is not a secret involving security of the country. At 2 o'clock, we'll direct your authorities to be present when I am taking up these files Saturday and Sunday. All the education department head of all the big bosses should be here. They should be watching the court work. We'll show that 11,000 files can be read in the courtroom. That too in Saturday and Sunday.
$61.
Apply.
Same.
61 is same. Okay, 60 and 61 at 2 o'clock.
$62. Bail hearing. Your Lordship, my senior is in hospital due to his mother treatment. He will come back to 2 p.m. Your Lordship may take the matter at 2 p.m.
Okay. Yesterday we suffered a tragedy. Rishiraj Sharma, he expired. On Saturday, he sang for us in a program, such a beautiful rendition of songs. 9:30 he was singing for us. I am so sad. And he was telling us while singing that he had some problems and he couldn't sing well. We remember him for one more reason. His mother sang for this court when the foundation stone was laid. The same song he sang in a Diamond Jubilee celebrations. mother started the journey of along with this court and son also. Really sad. Yeah.
For orders 34 and 35.
May I please, Lordship? My lord, this
Just a moment.
two matters are relating the case that earlier first page 34, Rupjyoti Bora. My lord, she was the subject teacher of banking at Gopur Higher Secondary School. Her post was provincialized by order dated 2/9.
Have you served notice on respondent number 7?
That's very yes, my lord. This on 16/3/23 we have served. And again on 23/20.
16.3, how did you serve? 16.3, how did you serve?
It was done through. Just served through. I think through. It was served through the registry of the court, my lord. But we have taken steps, my lord, on 23/23.
Okay. From the office note dated 25/4/2023. It appears from the as per office note dated 25/4/2023 from as per the track report, the postal item was delivered to the addressee. Accordingly, the court presumes the notice on respondent number 7 to be duly served. None appears on call for the petitioner.
My lord, I am for the
Mr.
secondary education.
MU Mahmood and counsel for the petitioner and Mr. U Sharma and his counsel for the secondary education department. For Mr. A Nayak for P Nayak for the finance department. Are present. This higher secondary education council has a standing council here. Who is he? Higher secondary education council. Just give a scroll, Mr. Das. Mr. Das, give a scroll. SC AHSEC. Just wait for some time. Let us see if the council is present. Otherwise, if the council comes, then it's okay. Otherwise, you can just type list in the admission column on Friday. (12/5).
On Friday.
We are waiting. We just wait for some time. If the council comes, then it's okay. Otherwise, this order will be there.
36.
I think 35 is also similar. my lord.
Same.
Your lordship, can we go to the order dated 24/3?
Just a moment. This is The next item 36. Order dated
24/3/2020.
24/3, yes. Who's appearing for Dudhnoi College? You are appearing?
Higher division lordship.
Yes.
Lordship, timing lordship instruction with K Google lordship.
It has come
Look,
after some time.
timing lordship.
Okay.
37.
May I please your lordship? My lord, I have filed affidavit in opposition on behalf of respondent number 11, my lord, on 3/5, my lord. This may come on record, my lord.
3/5.
My lord, my lord. Part name, my lord.
Okay, you got a copy?
My lord.
Today I am filing for respondent number 9.
9 has also filed today, my lord. I have received a copy, my lord, for 9, my lord.
Okay. All sides are duly represented. Let the affidavit in opposition filed on behalf of respondent number
Respondent number 11, my lord.
11 on 3/5/2023. We
3/5, my lord.
we tagged it with the record. The learned counsel for respondent number 9 submits that he is in course of filing of the affidavit in opposition today. So a copy thereof has been served on the learned counsel for the petitioner. Let the said affidavit also be brought on record. You want to file reply? Reply if any within 2 weeks. Just on, give a date after 2 weeks.
31/5.
Highly oblige you. Oblige.
And on the next date, be ready for hearing. This is a 2015 matter. You would not exonerate.
38.
Yes, secondary education.
38.
No, it is elementary education matter, review, my lord. 38. Person persisted. Judicial
No, it's a contempt case.
of contempt. I have to call, my lord.
Just let. No one is in the book. Professor Wilson. At 39. Okay. His review petition.
Review.
Yes,
Elementary.
review petition by elementary education. You file an affidavit.
This is a review by the government.
Yes,
Lordship, this matter was handled by Mr. R. Mazumdar, Lordship. Today.
we'll take this matter at 2 o'clock,
Lordship,
because here also the same thing is involved.
Lordship,
In your review petition,
Lordship.
at 2 o'clock, unless you bring on, unless you satisfy the court,
Lordship.
as to the names of the persons who are tutors, who are teachers.
Lordship.
those
Accommodated
things.
by the government.
No, I don't know. There are so many screening committee reports. There
Lordship,
are
lordship.
other reports.
Lordship.
I don't know what is right, what is wrong.
Lordship.
And then you say that everything has been done on the basis of WBC 1048. But this list of persons of 11,000 people for whose the screening was done
Lordship.
has not been brought on record.
Lordship.
So therefore, at 2 o'clock, be ready.
Lordship.
I have posed a question in previous matter
Lordship.
that unless you bring on record the numbers, the names of the,
The tutors and
Teachers.
teachers.
no, not tutor, teacher, whoever has been screened,
Lordship.
if their names are not there,
Lordship.
we'll give a date on Saturday and Sunday
Lordship.
where all these 11,000 files will have to be brought on record in the court.
Lordship. Lordship.
I will read these files.
Lordship.
If your government does not have good people
Lordship.
who know how to read and write,
Lordship.
we'll do the exercise and we'll show the state
Lordship.
that a single person can single-handedly read 11,000 files.
Lordship.
Correct,
Lordship will take about 2.
at 2 o'clock.
Lordship.
And all the officers who are in the, who are at, are in authority in the elementary education department
Lordship.
shall have to sit with me
During
to
the.
watch me reading these 11,000 files. Correct? At 2 o'clock.
Lordship.
39.
Last occasion, they have taken time, Lordship, to explain the instruction.
Yes,
My lord, here my lord, PG is not in the department, my lord, I instruct and my lord, P Chakraborty and N Sharma, all are left out.
not that. You see, what is required of you
So here is also petitioners were.
no, just a moment. Just a moment. Give me 2 minutes. On the last occasion, a statement was made that you have received instructions, you need some time to go through it. Because if you don't do it, then this,
He didn't, my lordship, he was transferred almost 2 years back, lordship. So now,
no, it's okay.
now
We
the director has come. So he was,
Mr. Sisti,
yes, lordship.
you see, while issuing notice, we committed a mistake of not asking him to be personally present and to take a bail, as is required in a contempt proceeding.
Yes.
For that, they are taking advantage. So in fact, whether the, except when the person has died,
Yes, sir, lordship.
we'll ask their personal appearance, that they'll have to explain their, during their tenure, what they did. They can't be exempted from appearing. A mistake of this court is costing the petitioner. We have to give a personal appearance. They'll have to come and tell us what they have done during their tenure.
Lordship, can you fix it at 2? I will get an instruction, lordship, yes.
Yes,
Yes.
yes.
There are more kind of petition from you now. I'm hoping I'm able.
You can take the second, this,
Yes.
our records.
41.
Non-appearance call for the petitioner or for the respondents. Elementary education department, who's there? You're there?
In contempt, yes.
We'll direct your authorities to transmit the order of this court to this Pritam Saikia and Sumitra Dev. They are required to be personally present on the date we are fixing.
Item 41, item 41, Lordship.
41.
Yeah, Pritam Saikia, he retired, Lordships.
No, he may have retired,
Retired. And
but he'll have to come to court.
yes, he has engaged the earlier council, but they have not appeared, Lordship. That is the
No.
irony, Lordship.
No, I understand.
He was in the presumption that his concerns were being.
No, that is
representing
okay.
him, Lordship.
That is okay.
Now
That
they are
is,
not here.
no, that is okay.
Yes.
For that, he has remedy against his counsel. But so far as the court is concerned, unless we enforce our orders, there's no point sitting here passing orders if the authorities don't comply with it. So we are merely asking
Now he can take the instruction from the present incumbent, Lordship.
No. In a contempt that is dangerous. Because the new parties will have to be impeded. Without that, I'm not asking the standing council to do anything. Only to transmit the order of this court to your director elementary education, so that he can use his office to transmit the order of this court to Pritam Saikia and Sumitra Dev. Correct, only that much. The respondent numbers 1 and 3 are unrepresented. Mr. P. Sharma Dhanet, P. N. Sharma Dhanet, standing counsel for the Elementary Education Department, who is present. On being asked, has stated that the respondent number 1, Pritam Saikia, has retired about 2 years back. And respondent number 2, Sanjeev Kumar Bhuya, has expired. And is Sumitra Dev, he is in service?
She was earlier DO of Kasar, now she was transferred and.
Okay, and the respondent number 3, Sumitra Dev, has since been transferred from Kachar. Next paragraph. As the respondent numbers 1 and 2 remain unrepresented, the learned standing counsel for the Elementary Education Department is directed to transmit a copy of the order passed today to the Director of Elementary Education Assam to transmit the said order to Sri Pritam Saikia, former Commissioner and Secretary to the Government of Assam Education Department, and to Sumitra Dev, DEEO Kachar, Silchar, wherever their present addresses are, and to submit a proof of such service to the court on the next date. Next para. On the next date through the learned standing council. Next para. For the limited purpose of producing before the court the proof of service of notice to respondent number 1 and 3, the registry shall reflect the name of Sri P. N. Sharma, learned standing counsel for Elementary Education Department, in the cause list by listing the matter next. Next para. Notice is issued to. This notice is issued will be in the above, where I've said that the Pritam Saikia and Spencer have not appeared. Issue notice to respondent 1 and 3. To cause us to why on their failure to inform the court about the steps taken during their respective tenure, they should not be proceeded in this matter. Then you say that notice is to so and so, no? That paragraph is come here. Next paragraph, this notice is made returnable on so and so, list on after 5 weeks.
12, 6. Forty-two.
Yes,
Your Lordship, we recently obtained certain instructions from the client regarding the matter of documents. Your Lordship will kindly grant us a week's time to go through documents and finally submit it for this court, whether you want to matter process or matter or not.
okay.
Yes.
On the, both sides are duly represented on the prayer made by Mr. M. Sharma and counsel for the petitioners. Matter stands adjourned to adjourned today, list after 2 weeks.
I'm grateful, Your Lordship.
43.
Lordship, kindly pass over the
Forty, Lordship, only on last occasion also I had submitted that they were already engaged on fixed pay, Lordships. And our instruction is that, Lordships, that they are getting their monthly wages regularly, Lordships.
Okay, this is item
As a 43 contempt, Lordships.
43. Okay, let Mr. Bora come. He's asking for the time for time being.
Time being.
44.
Let me, Lord.
Yes, Mrs. Agia.
Non-compliance of the order dated 3/5/2018, my lord. The respondent has filed one affidavit, my lord.
Where is the order of this court?
Order, your lordship will find page 10, my lord. 10 onwards. Direction, your lordship will find page 13, my lord.
Just on. The appearing correspondence.
Respondent number 6 now has filed an affidavit.
Okay. Mr. P. J. Sehgal and counsel for the petitioner is present. None appears on call for any of the respondents. Although notice is duly served. Next para. Mr. The learned study was for the elementary education department has submitted that respondent number 3, namely Sanjeev Kumar Bhuma, is expired. Next paragraph. As the respondents remain absent and the orders of the court has not been complied with. Mr. Naik, you are appearing for this Anurag Goel.
Yes, Lordship, right. We are appearing for Anurag Goel, but our name is also appearing, Lordship, but I'm looking for the brief, Lordship.
Okay, look at this file. You see, in short, if I have understood it correctly, this court had given a finding about the engagement of people who are have the visual disability.
Lordship.
And there was a direction to appoint them within a particular time frame.
Lordship.
Now, in the affidavit of respondent number 6, they are taking a stand which in a contempt is not permissible. If you just look at the stand taken in the affidavit. So we'll have to call these people personally because since they have not.
Health Department.
Lordship, if I may submit, Lordship, here the problem is, Lordship, the parties which have been made in this, Lordship, they have, CHSFW has sent a proposal to the government, my lords. Now, the person who are looking into the matter, my lords, they have not been made a party in this matter, my lords. That is why, my lords, if in the meantime, if my learned friend can implead those people.
No, you see, it's a, what do you call this? You see, 2019, correct? You don't bring these things on record by filing an affidavit.
Lordship.
Why should we take notice of some submission which you are making? Let these people who have dealt with the matter, they say that we have not dealt with the matter. How can we take cognizance of your statement and then start implementing people
Lordship,
on the premise that these people and not and the other peoples are dealt with the matter?
Lordship, I'll just make a tiny submission, Lordship. Here, I'm representing the respondent number 4, who is the Director of Health Service, my lords. So the job of the health service was to send a proposal for approval to the government, my lords. Now that proposal is pending in the government, my lords, and the respective authorities have not been made a party, my lords. I am not on that, my lords. If my learned friend, in the meantime, if he can make them a party, because there is no commissioner, my lords.
You will have to bring on somebody will have to take responsibility and bring a statement on record. It's a contempt proceeding.
Lordship.
We'll move against those persons who are before us.
Lordship, that is why Lordship, I just want to submit the right people who are actually responsible for.
Bring it on record by filing an affidavit.
Lordship, I can give them the names.
No. We won't take that. It's a contempt proceeding.
Lordship.
Everything is to be brought on record.
Lordship.
You see, let me tell you, in a contempt proceeding, assuming you are fair, you are not making that submission.
Lordship.
But let us assume that now somebody makes a submission on behalf of the contemners
Lordship.
that X, Y, Z, they were looking after the matter and now they are all dead.
Lordship.
Correct. Let us say that this affidavit comes. In that event, what do we do?
Lordship, the new incumbents are made a party, and in the meantime, Lordship.
No, because you see, the duty was cast on them, the persons who are before, who were before us, to see that the appointment orders are made.
Lordship.
So they will have to pursue.
Lordship. Lordship, I bow down to that.
Unless you show me an authority on the point that the authority on which direction was issued was merely required to act as a postman.
Lordship, that I have not bought it on record, but we have the
Unless you
instructions.
brought in on record, no.
Lordship, that is, Lordship, I apologize for that, Lordship. Lordship,
Instruction with you doesn't help us. You make not record, then we'll see. We'll examine what these people had done.
just, Lordship, in this case, Lordship, I'll seek 1 week's time, Lordship. I'll file the
We'll give you,
affidavit.
not one, we'll give you 2 weeks, but waiting on
I'll
record.
file the affidavit, Lordship, and I'll also bring in the current incumbent, my lords, because so that necessary action can be taken against.
Because then it's very easy, you see. In short, may I just tell you in one sentence? There are authorities on the point of by this court as well as the Supreme Court, which says that the government must speak in one voice.
Lordship.
Correct.
Yes, Lordship.
So now the X will say that Y will do it. Y will say that my peon did not put it up. Peon will say that no, this thing was, I am an uneducated person. I never knew that this has to be brought to the notice of the director, and therefore I am sitting over it.
Lordship.
So
Yes.
therefore, the blame game goes on to this poor, what you call, uneducated grade 4.
Your Lordship, here we are making an endeavor to get the message ourselves personally to the right people, Lordship. That is the,
Bring on record.
that
bring
is
on-
the only thing
bring-
I'm praying
Bring on
for.
record, we'll give you time.
Lordship.
Don't worry about
That,
time.
once that is there, Lordship, so that the people who are actually responsible, I want them to be part of this.
Okay.
Lordship.
PJ Sekhar and counsel for the petitioner is present. Mr. A. Sharia, Mr. P. Nayak, appealing for respondent number 1 is also present.
No, Lordship, I'm appearing, Lordship. I'll be at
Okay,
1 and 4, Lordship.
1 and 4, Mr. A. Shalia, counsel appeals for 1 and 4, and pays for some time to bring on record and affidavit.
Lordship,
Next para. It is submitted at the bar that respondent number 3, namely Sanjeev Kumar Bhuya.
no, Lordship, 1 and 4, Lordship.
No. Sanjeev Kumar Bhuya.
Yes.
Sanjeev Kumar Bhuya has expired.
Oh, Lordship, that,
To stop. The other respondents, number 1, 2, 4, 5, and 6 shall take notice that this court has not exempted their personal appearance. To stop. Accordingly, the non-filing of affidavit by the said respondents, except for respondent number 6,
Yes.
is not at all appreciated. Full stop. They are put to notice that in the event the orders of the court are not complied with, the court may issue directions to them for their personal appearance on the next date. This one, after 2 weeks, due date,
24/5.
All right.
45.
right.
45.
45, Lordship, that amount has already been paid to the person, Lordship. I have given the instruction through mail,
Okay. Yes, Madam.
an amount of 65,136 has been already been drawn and paid to Nurul Islam, Lordship, retired headmaster of so and so school.
None appears on call for the petitioner. Mr. SMT Chisti, Leonard, standing counsel for the Elementary Education Department, submits that although he is not appearing for any of the respondents and has appeared
By said.
And that he has appeared only to bring to the notice of the court that the claim of the petitioner for aerial salary for the period from 1/10/2011 to 28/2012 to an extent of rupees 63,136 has been paid to the petitioner, namely Nurul Islam.
Yes.
How? He's been paid how?
Is it paid through Treasury Office, Lordships? I have also the royal certificate, Lordship.
Through the consent,
Through account number, so and so, Lordship, in
Just
his
a
account number.
through the treasury office to his account number.
Yes. The second page to print, the second page to print.
Okay, just keep that blank, account number so and so. And accordingly, it is submitted that the order dated 17/9/2018 passed in WPC 586 of 2017 has been complied with. First off, it is submitted that the instructions had been sent to the court by mail. So the same could not be
Yes,
done.
this is the account I have.
The printout of the said mail is kept as a pass of record.
To account number 003-010-2621, PNB, Punjab National Bank, Moirabari branch, on 01/12/2021 by the District Treasury Office, Morigao.
Just copy this part. Put the entire letter, give an letter. Give the entire letter, just part. Next one. Accordingly, it appears to the court that the order of the court has been complied with. This nonetheless, as the counsel for the petitioner is absent on call, finds of this is the matter of John today. Next, it is made clear that if the petitioner remains absent on call on the next date, the court will proceed on the basis of the contents of letter dated 5/1/2022 quoted above.
Obliged.
The said letter is made a part of the court. List on
17/5. 46.
May it please the lordship. Lordship subsequently lordship against the order of the single judge lordship, a writ appeal was preferred lordship. And the honorable division bench remanded back the matter before the single bench for fresh consideration lordship. And
This-
one more writ petition is pending between the same parties lordship involving the same issue.
Sir,
In that
contempt has
case,
become
contempt will
infructuous.
become
Yes.
infructuous then. Contempt will become infructuous then.
Yes.
Mr. Karim.
Lordship.
Mr. R. Karim, learned counsel for the petitioner, has fairly submitted that that against the order dated 28/8/2018 passed by this court in WBC 2638 of 2017, a writ appeal has been preferred. And the said order has been interfered with and the matter was remanded back for a fresh consideration before the learned single judge.
lordship.
So it is submitted that the said writ petition is pending for disposal.
Lordship.
Next, it is also submitted that another writ petition between the parties being WPC
425 of 2023.
is also pending for adjudication. Next, Mr. SMT Chisti, learned standing counsel for the Secondary Education Department is present. Next, in view of the said submissions, the court is of the considered opinion that in view of interference with the order dated 28/8/2018 in WPC 2638 of 2017, while orders passed in WA
WA 201/2020.
221/2020, this contempt proceeding is liable to be closed. Next, according to this contempt petition stands closed in view of the subsequent development in this case.
Obliged, lordship.
I'll take a break and come back.
Yes.
কিয় মানে বিচাৰিছে মই ইমান দৌৰত আমাক পাতি এইটো চাৰ্ভ হৈছে
SEC for listing the matter next.
36, time being.
This lordship, as per lordship's direction, my friend has taken the steps for issuance of notice to newly incumbent respondent lordship. Whether lordship notice is served or not lordship, that part lordship. Unless and until petitioner's principal has taken steps lordship, we are handicapped lordship.
Notice has been issued to respondent number 6.
Lordship.
Respondent number 6. Who is respondent number 6?
Number 6 is the principals of the college lordship, Goodnight College.
Newly impeached principal of the college. On the last occasion, he was impeached.
On 24/2023, as per lordship's order, it was implemented lordship.
So P. Bharadwaj done counsel for the petitioner. And Mr. K. Gogoi Leonard. You are appearing as?
Respondent number 5 lordship, as extending counsel higher education department. lordship.
Okay, appearing as the counsel for respondent number 5 are present. Next, in view of the office note dated 29/3/2023. Is this matter before the Lavasma Court for passing appropriate orders as regards service of notice on the newly imputed respondent number 6, 7. 6 or 7?
6 lordship, 6, it will be 6 lordship.
It should be 6.
Lordship.
Oh, 6. But Mr. Gogoi,
Lordship.
This implementing of this principle, how will it,
Lordship,
how
because
will it
the,
affect him?
because the lordship, the lordship, that particular lordship, DPC held is to held by the college lordship, and they have to send proposal lordship.
In light of the orders passed in the in this in the judgment,
Lordship,
the respondent of 5 was asked to send a
5 is the lordship, then the principal lordship, it was be then principal lordship. Respondent of 5 is the Gopal Kupal, principal of the Dunoy College at that point of time, lordship.
okay.
Lordship. No. Origin petition. Origin petition. No, not in the company. And by constituting a DPC lordship, they have to take in the resolution lordship.
Okay, then you this might. Next, brother. Thereafter, the matter will be listed with the court for further orders. Okay, let the service be completed in the Lahozima court.
Lordship. Lordship.
21, 22.
I'm appearing for the respondent number 4 and 5, I'm filing affidavit to the lordship, it is already ready, lordship will give a copy to the lordship.
Okay. 2018 matter you woke up, your client spoke up now.
That's the problem is we have sent it long, but the date was not fixed, so I thought that this Saturday only I got the record, so. It's a second round of litigation law.
I understand with the volume. Okay, you're filing it today.
Yes.
You want to respond to it?
After we get a copy, my lord.
He's giving it to you right now.
Yes, yes, I'll give him.
How much time to respond?
I have not seen the affidavit, but after 2 weeks.
Okay.
Lordship, I am preparing for respondent number 6, inquiry petition. In the meantime, I will also file the affidavit.
No, you do it together because you see, unless you see
Yes,
2018, 2000, this old matters
Yes,
will
yes.
be listed time and again.
We'll give a copy
We-
to him, lordship, at the same time, lordship, we can give the
You
reply.
file it within a week.
Yes, yes.
Give a copy to him, we fix the matter, give him 2 weeks time to respond. We will list it after 4 weeks. Also as a duly represented. Mr. S. Sharma, and senior counsel, assisted by Mr. T. K. Bhuyan, counsel for respondent number
4 and 5.
4 and 5. I submitted that the said respondents are filing an affidavit in opposition in course of the day to day. By serving a copy of the same to Mr. P. D. Nair and counsel of the petitioner. Next para. Mr. J. Dekar and counsel appearing for respondent number 6. Praise for and is granted 1 week's time to file affidavit in opposition in the matter. By serving a copy thereof to the learned counsel for the petitioner. Next para. 2 weeks time is granted to the, 2 weeks time is paid for and granted to the learned counsel for the petitioner to respond if so advised. Next para list on after 4 weeks, give a date.
12/6.
Yes.
My lord, deeply obliged.
59.
You are going for a hearing of this matter. Then I'll take it up as the last item in the day, in the board.
Or your lordship may fix it on Thursday, my lord.
No, because Thursday I have other parted matters fixed.
My lord, what I want to bring it, my lord, because the affidavit, which was before the learned single judge, on which I was just harping upon, my lord. Can I bring it on record before the review court, my lord? Because, my lord,
No,
that is,
it's already, if it is
it's
there
there
in
in
the
the
single
single
court, then we'll have that record here.
so then, my lord, can it be on next week here, my lord? Not possible.
No, these Tuesdays and Thursdays I have fixed so many matters that I am unable to manage the board.
Because today, my lord,
Because
some-
I can take up the
some-
matter today.
some problem is there, my lord, if your lordship. Second,
We'll fix it some, in a regular day,
my lord,
because Tuesdays and Thursdays I am not being able to
next
accommodate.
Monday, my lord, next Monday. I'm sure definitely I'll do it. Monday.
Okay. Also as a duly represented on the prayer made by Mr. P. K. Roy Choudhury, the counsel for the petitioner. List on, give the next date on Monday.
15/5.
15th. Obliged.
Is it fixed on Monday, Lordship? Obliged.
Forty-three. 43.
48 or
43.
43.
I'm sorry.
Here SMP 60 will appear, my lord. Contextual period. So I have just called.
Okay, we'll pass it over the councils. Yes, yes, Mr. Sharma, you can call. Mr. Shastri. Yes. Yes, you have been paid the money.
No, not yet.
But the statement was made that you are starting to receive current salary.
No, lordship, that is from 2021.
No, whatever be that, you see, that is the statement that the back wages, they need some time to process the proposal. Current,
Yes.
current salary you are started receiving.
Yes, that is true.
Huh.
That is true, lord. Yes.
What
as per
about
that-
what about the area, Mr. Sisi?
That particular instruction, lordship,
No, for current salary, he has started receiving it. Only the, now what remains is the back wages.
that instruction, lordship, I have to give. Lordship, single order asin, na? Single order asin.
Both sides are represented by referring to order dated 27/3/2023 from Mr. SMT Chistri and standing counsel for the This is elementary education,
This secondary.
so secondary education department prays for some more time to obtain instructions as to whether as regards status of the claim of the petitioner for back wages. Next paragraph. The respondents are reminded that till date, the personal appearance has not been dispensed with. And therefore, they should do the needful to bring the to comply with the order of this court dated 10/4/2018 passed in WBC 4124 of 2018. The pendency of this contempt proceeding shall not be a bar for the respond number 2 to comply with this said order. Next para, the learned counsel for respond number 2 shall send a downloaded copy of this order to the respond number 2 to bring this order to her notice. To his notice. Next para. In the meanwhile, the petitioner shall put the present director of secondary education Assam to comply with the order of this court and thereafter file an appropriate application for impeding the new incumbents. Next one, list after 2 weeks. You impede those people, otherwise this is not proceeding.
47. 47.
Yes, you have instructions in the matter.
No, lordships, in this, I think with the P. Bora lordships, he was for the elementary, but his daughters are not well, so he has not come. He has requested me to take time. In both 47 and 48, both the councils, they are not well lordship today
Okay.
for the respondent side.
None appears in call for the petitioner. So, on behalf of Mr. P. Bora and counsel for the respondent. Mr. For the respondents, Mr. SMC learned standing counsel for the secondary education department prays for time as the as the council record could not appear today.
Yes.
First of all, Answer Justice Matters stands adjourned today. List after 2 weeks.
Yes.
48.
Same order.
Same order lordships.
You are there.
Yes.
We give him some time. Mr.
MS Ali.
Mohammed MS Ali for the petitioner is present.
Here on paper and need to end the
Maybe
conversation.
on it then, my lord. If possible, that may be given.
You want a date?
After 2 weeks, it will
Okay.
come.
Give a date after 2 weeks. Here on behalf of.
And Fukon, need to say Fukon.
Acha, Ms.
and
N. Fukan.
22/5.
Problem.
49.
It is in fact, complied with.
Completed, okay. Both sides are represented. You just don't write that. Mr. A.M. Barbuya, upon instructions, has submitted that the order of this court has been complied with, and therefore he has instructions not to press this matter. Next, for Mr. B. Deori, learned counsel for respond number.
Director of pension.
Appeals for director of pension, and Mr. S.M.T. Chisti, learned counsel for responding members.
Respondent number, petition of petition.
Also are present. Next,
Okay, if
matter
that is happening.
stands closed on compliance.
Obliged.
Just give the respondent numbers.
Yeah, I'll be, okay.
52. And then 52. Yes. My lord, this is a review petition, my lord, order, my lord, at page 61, my lord. Review because, my lord, as per my lord, Provincialization Act 2011, my lord. Under section 4, my lord, all service are, my lord, deemed to be have been provincialized, my lord, subject to the condition that if whether they are fulfilled or not, my lord. Here, my lord, page 61, my lord, is the order, my lord, it was provided that, my lord, that their service to be considered under the Act of 2018, my lord. My lord, kindly, my lord, I beg to just go, my lord, to page 40, my lord, provincialization order, my lord. Here, my lord, as per my lord,
This Act of 2011 has been repealed.
repeal, my lord. But
Correct.
here, my lord, fact is different, my lordship. Just kindly have a look, page 40, my lord. Original provincialization order of all the staff, my lord. Teaching staff of the college, my lord. Page 40. Here, my lord, provincialized, my lord, from serial number 1 to, my lord, 9, my lord. All the professors are, my lord, provincialized, my lord. And why, my lord, then I was not, we are not provincialized, my lord. This is, my lord, page 44, my lord. It was sent
Sir,
by,
just before I start hearing you, you see, only one question. You see, when this act is repealed, it has an effect.
effects, my lord.
The effect of a repeal is that the act doesn't exist.
Yes, my lord.
So any action which calls for a fresh consideration can only be under the new act. You see, the savings clause will only save whatever actions they were already taken.
Yes.
But those actions will not cover, so far as my limited understanding goes, it will not cover a fresh consideration. You were dropped,
Yes, my lord.
correct? That means for the time being, we understand that your service was not provincialized then. So if today we give a direction, it can't be under the enactment which is not there.
My lord. In this regard, my lord, with all respect, my lord, some judgments passed, my lord. I have annexed, my lord, those judgments.
So that
Yes, my lord. My lord, regarding my school also, my lord, some judgment passed, my lord. After my immediately my order, my lord, page 63, my lord, one judgment, my lord. Page 63, my lord, then another order, my lord.
Mr.
last-
Balbania, Mr. Balbania, the division bench has now what you call past and judgment, where it says that any new constitution will be under the new act.
Yes.
It amounts to prospective overruling, and the Supreme Court says that the effect of what you call the effect of repeal, for that we have judgments. In this order, I don't find that the effect of the repeal has been considered.
We are.
On recent judgment of Supreme Court is Surya Kumar Okra, my lord.
Yes, Surya Kumar Okra, yes.
And moreover, my lord, the review is not applicable here because the case of the petitioner is that, my lord, this court has passed an order, my lord. Thereafter, subsequently, in another writ petition, court has passed another order, my lord. Now, my lord, under review jurisdiction, it cannot be reviewed, my lord, because there is no apparent on the face of the apparent error in the face of the record, my lord. If he is agreed, my lord, it has to be filed through an appeal, my lord. And moreover, that, my lord has rightly pointed out.
Give that citation of Surya Kumar.
Yes, sir.
Give that citation. My lord, spelling is SURJYA, correct? It's a
SURJA
SURJA, right? Huh.
KUMAR.
Yes, what is the citation?
Surya Kumar. My lord, I don't have the citation, my lord, but I have the case number.
No, I have it. This is something I've seen.
Surya Kumar.
SURJAKUMAR.
JAKUMAR. Surya Kumar. One word, my lord. This is
I am State of Manipur, Surya Kumar. Yes,
State of Manipur versus. There are para 43, sorry, 23. 23, my lord.
because here it says, Mr. Barbuya, because this act was set aside by this court. So the in this Surya Kumar, what the Supreme Court says is that once it is declared it is set aside on the ground of unconstitutional, it becomes void ab initio. Therefore, it will go to the date of its enactment. There are reference to many cases. In fact, two Supreme Court judgments, Behram Khurshid, Pesi Kaka, and Deep Chand. This Behram Khurshid is more important because it's a constitution bench judgment. So,
Another date may wish for, I will go through this judgment.
okay. Mr. A.M. Barbuya, counsel for the petitioner, learned counsel for the petitioner, and Mr. S. Das, standing counsel for the Higher Education Department. You are also appearing? The name? And sense of counsel for respond number. You have a respond number? 3.
Governing body.
Expert. In view of the nature of grievance raised in this review petition, the court has 2 queries. Number 1. As the Assam Venture Educational Institutions within bracket Provincialization of Services bracket close Act, 2011 was declared unconstitutional, which led to the enactment of the Assam Education within bracket Provincialization of Services of Teachers and Reorganization of Educational Institutions bracket closed Act 2017, by which the 2011 Act was repealed. Whether the direction of this court contained in order dated 12/2019 No, no, where is your order, Mr. Barbia?
Page 61.
It's 61. Order 11/12/2019 passed in WBC 9190/2019. Is liable to be reviewed. Number two, it primarily appears that on declaring a statute to be unconstitutional, comma, it primarily appears that the act has been, that the act would become void ab initio. So the subsequent repeal by the 2017 Act would also take effect that only those actions which are saved could prevail. Comma, which does not include right which could not be fructified under the 2011 Act. For which whether this review petition would be maintainable. Next, the court query the counsel the petitioner pays for is granted. How much time?
Next week.
We have some time. Next, accordingly. Does this matter on 17/5?
Hello. Applied.
53.
Yes.
This review application has been filed against the order dated 21/6/2019, that your lordship will find at page 69 of the review application. It starts at my lord, page 66. The relevant portion is at page 69.
Notice has not been issued.
Notice was issued, but the opposite party has not issued yet. Service is not complete,
Oh.
madam. Notice was issued by the order dated
No,
12
just one.
to
Just one.
Fine.
Order should have not been asked by this. जाते होते रहेगा. Who is respondent with 7?
One of the elected members. madam.
Yes. So why this review?
My lord, what happened? This petitioner, the opposite party reacted, petitioner approached this honorable court. I was praying for payment of their remuneration as per my lord, rule 15 of the Assam Panchayat administrative rules, my lord. which stipulates that an elected member of a panchayat are entitled to some remuneration. At that relevant point of time, it was 1,000 per month, but by subsequent amendment, it has been enhanced to rupees 3,000 or 5,000. Now, my lord, the honorable court on the very first day itself, my lord, disposed of the petition, directing the deputy commissioner Saraido and the block development officer to pay the remuneration, which in my humble submission is not permissible, because the rule says has to be from their own fund or from the fund of the government. And subsequently, my lord, it is the Panchayat and Rural Development Department who deals with the fund of this Panchayat, my lord. Lordship will kindly come to Rule 15.
No, you are right.
So the deputy commissioner and the block development officer has no role in the payment of this remuneration matter. And the petitioner disposed of the very first day, so this aspect of the matter could not be brought to the notice. And today, my lord, in the morning, I was having a discussion with my learned colleague, Mr. P. Nayak, who represents the Panchayat and Rural Development Department. He was telling, my lord, similarly in other Panchayat also, there were non-payment issues, and a batch of petitions were filed, which had been disposed of by the Honorable Court number 17, directing if the remuneration cannot be paid from the own sources of the Panchayat, then it is the Panchayat and Rural Development Department who releases the fund. They have to look into it and they have to pay, my lord. But that order I am not having today, because verbally informed to me. And otherwise also, I can place the rules, my lord. The DC and the BDO has no role. Your lordship guidance, I can say fresh steps.
In the new book, I am not being able to locate. Since I'm acquainted with that old book, it's not very easy for me to find here. But you see, there's the reason being why I'm trying to search it is the provision for order 3. I don't know, it seems that no one takes this very seriously. this same provision has been referred to in one of the rules of the High Court. This order 3214 down below. 144. What does it say?
My lord, appointment of a pleader.
Huh. Next, you'll find A. Review. So you could have served long back the notice to the council. It was at the end of the matter. Because now the problem is that
My lord, that thought my lord crossed my mind, but normally what happens? Unless my lord there is a direction for the court, sometimes they are reluctant to.
they can't do it. That's why I'm saying there's a
That's the
provision in the
provision.
rules. This old book I'm acquainted with, there is a specific direction that subject to order 321 in the High Court rules. Subject to order 321.
Correct.
One can't say that he won't appear. But the fact is that
Then I'll try to serve a copy, my lord.
because all this
They are represented us.
in this case, nobody represents them now.
In the petition, they were represented by us. So
Because here there is a presumption of service.
yes, sir.
That is the whole difficulty. I think better send a fresh notice.
Fine.
And also serve it to the council.
Yes, at page 69, the name is witnessed. In the order, my lord. Page
Yes,
six- Page 69,
yes. Give him a copy also.
yes.
Uh, uh, Taking note of the fact that notices on the respondents were issued long back.
My lord, on 12/2/21 position. Order dated 12/2/21.
12 to 21,
Yes.
and that service of notice on the respondent was 1 to 3, 1 to 6 and 8 was presumed to be served. Which was issued long back on 5/3/2021. Or the court is inclined to direct the petitioners to take first steps for service of notice on the respondents by registered post with AD So in addition, in terms of the provisions of order 3, rule 4, explanation A, or the court is inclined to direct the learned counsel for the petitioner to serve notice on the counsel appearing for the petitioners, namely Shri Hamidur Rahman and Ms. Ruby Kogoi. Next paragraph. Steps within a week from today.
Yes.
Notice is made returnable on, give a fixed date after 5 weeks.
19/5, 19/6.
List accordingly.
Deeply applied.
This next paragraph. Is this stay operating? No.
My lord, there is no stay operating, but my lord, we made a prayer because they have filed a contempt case also. So in the order dated 12/2/2021, this honorable court directed us to bring it to the notice of the court, taking the contempt matter that the review is pending.
Next paragraph. At this stage, the learned counsel for the petitioner prays for an interim relief as a contempt proceeding has also been initiated.
Contempt case number 610.
Being COPC,
Contempt case number, my lord,
con case PAC number
610
610
of 2020.
2020. 2020.
Yes, sir.
Oh, okay. Thanks, Parag. The learned counsel for the petitioner has also submitted that by order dated 12/2/2021, while liberty was granted to the petitioners to bring the pendency of this review petition in the proceedings of con case C 610 of 2020, by providing that the prayer for stay would be considered after hearing the learned counsel for the respondents. First, it is submitted that by order dated 2/2/2022, passed in the proceedings of Lahore Zima Court, service is presumed in respect of respondent numbers 1 to 6 and 8, and that as per the order dated 2/11/2022, passed in the proceedings of Lahore Zima Court, notice on respondent was 7, being delivered to the addressee on 30/8/2022. The service was complete. Next paragraph. Taking note of the fact that by orders dated, orders passed in the laws, orders dated 2/2/2022 and 2/11/2022, passed in the proceedings of Lahore Zima Court, notice, service of notice on respondents is deemed to be accepted, and none appears on call for the respondents. The court has taken up the prayer for interim relief. Next paragraph. The learned counsel for the review petitioners has submitted that this court by the order under by order dated. Where is that order?
Well, at page 66, it starts 11%, page 69. Order
69.
dated 21/6/19.
The order dated 21/6/2019, passed in WBC 4243 of 2019. Directed the Deputy Commissioner Saradio within bracket respondent number 4 in the writ petition bracket close, and the block development officer within bracket Sonali development block within bracket respondent number 6 therein to verify the claim of the petitioners and to release the arrear salaries. First off, it is submitted that the private respondents included in this review petition were the writ petitioners, and they were elected members of the
Number 2, Abhayapur Gram Panchayat under Sonali Ansarit Panchayat.
number 2, Abhayapur Gaon Panchayat under Sonali Ancharik Panchayat,
All right.
Soradio subdivision, and being elected president and vice president and members, they were entitled to remuneration. So it is submitted that as per the what is that act? Panchayat Act.
Yes, no, but it is the Assam Panchayat Administrative Rules 2002.
Under the Panchayat, Assam Panchayat,
Within bracket administrative, bracket close, rules 2002.
the payment of remuneration was to be made by the funds of the Panchayat
From their own source. or
From their
the
own
funds
source.
of the government.
or
My lord, Lordship will kindly come to the amendment, my lord. At
Just-
page 51 of the review petition. Page 51 it starts, 11 portion is at page 53. Amendment of Rule 15. Earlier it was 1,000, now it has been made rupees 5,000 to the Gaon Panchayat and Gaon Panchayat own resources. And in sub-rule 3, my lord,
own resources and or out of the devolution of funds
yes,
to the Gaon Panchayat. Accordingly, submitted that the petitioners were the deputy commissioner and the block development officer have got no role to play in the release of remuneration to the elected members of the Gaon Panchayat. And that the said officers are not the drawing and disbursing officers for the dues, if any, payable to the respondent numbers 1 to 7. No, not 1 to 7. Who were the petitioners?
my lord, 1 to
1 to 8.
8.
Respondent was 1 to 8. Full stop. Court finds force in the submission made by the unconstitutional petitioner. Full stop. Under such circumstances, the court is inclined to stay the enforcement of the order under review dated
21/6/19.
21/6/19 passed in passed by this court in WBC 4243 of 2019. Till the next date of listing. This order to take steps will come after this.
Deeply obliged, Mr.
This one's also. We give you liberty to serve a copy to the council in the this contempt. They are same council.
Contempt, my lords, a different council, Mr. DJ.
Council. Next, we just add there on a prayer made by London Council for the petitioners. Comma, as a matter of abundant. In addition to the service to be made by registered post to the AD and to the London Council for the red petitioners. Comma, liberty is also granted to the London Council for the petitioner to serve notice to the notice of the process to the London Council appearing for the respondent numbers 1 to 8 in the proceedings of con case C number
610/2020.
2020. This one's also,
My deeply obliged.
54.
yes, review petition. What has happened? You'll have to do the hearing then.
Your lordship, compromise has already been taken place between the parties.
No, I understand, but you see, review petition, I can.
Only your lordship, only to make payment. And that may be placed before this week, Your Honor.
Okay,
Parties are committed to make payment before the,
okay, both sides are duly represented. Mr. R.B. Shah, London Council for the petitioner, submit that both sides have compromised the matter. And the only issue between them is the payment to be made by the petitioner
yes,
to the respondent. And he submits that it could be done within a week as per instructions to him. Full stop. In view of the statement made at the bar by London Council for the petitioner, the matter stands adjourned today. This after 2 weeks. Says South and Council for the respondent is present.
55.
Lordship, Mr. Escobar.
I file against a violation of an order, interim order. But the
Okay, just a moment. Yeah, yes, what you're saying?
Mr. Escobar and Lakeside Court 1, so let the matter be passed over for time being.
Oh, okay. Okay, after some time.
Lordship, I am appearing for F. Chaudhary. Item number 56 along with 41. Today he is out of station. So Lordship, kindly the date may be given for next week.
Okay, both sides are represented on the prayer made by London Council for the respondent. The matter stands adjourned today. List. So 22 review petition. List after 2 weeks. You give a date after 2 weeks.
29/5.
Okay. Yes, 57.
This is time for a minor correction, my lord. The petitioner father name wrongly recorded my lord Montaz Ali instead of Hamzad Ali. It was in my part, my lord, in cause and title, it was wrongly written my lord Montaz. That is why my only part the my lord petitioner father name written as my lord Kalamia oblique Abdul Qadir my lord.
Father's name should be,
My lord Abdul Qadir alias Kalamia. Kalamia is my nickname, my lord, and the good name is my lord Abdul Qadir. But in both in order sheet, post title and order sheet both are my lord inadvertently written as Mustaz Ali.
you're not son of late Muntaj Ali.
Yes, my lord.
Oh, then you'll have to make some corrections here.
Yes, my lord. Post
Uh,
title is it was my lord.
No, this is not a part of the order.
My lord,
You,
still my lord, I post and
no,
title, my
Mr.
lord.
Ali, please understand.
Yes,
let
my
me
lord,
clarify.
I'm sorry, my lord. Similarly in post title, my lord.
So cost title is not a part of the order,
Yes,
correct?
my lord.
You hear me?
But it is
Mr.
restricted.
H. Ali, learned counsel to the petitioner, submits that in the cost title of the bail application, the father's name of the petitioner was recorded incorrectly. Next paragraph. As cost title appearing in the order is not a part of the substantive order, but it is copied from the cost title, the learned counsel for the petitioner shall make necessary correction in the cost title of this application to make it an application for modification of the alteration of the correction of the cost title in AB 225 of 2023. So the same shall be done in the presence of registrar within bracket judicial, who would make necessary correction in the cost title. And thereafter, this matter be placed before the court for a judicial order to make the for consequential order. This application must be application for correction of cost title.
Yes, ma'am.
You
Yes.
do it in the presence of the registrar, then it will come to us, we'll make the order correction. But that is not a part of the order. It is copied from the.
Ma'am, I write in cost title in petitioner I write my lord. But in
Instead
cost
of,
and similarly
instead of
cost-
order, you make it cost title of the AB. Registrar will do it, then it will come here,
Yes.
we'll correct it. Yes, you wanted to say something?
No.
Lordship, item number 58, I am for the petitioner on behalf of R. Sinha. He is not feeling well today, so kindly matter may be fixed after Sunday. Lordship.
Yes.
Yes, unwell. Otherwise, it is already this one is decided by your lordship. Sort that.
Okay. Both sides are duly represented. Prayer for adjournment is made on behalf of Mr. R. Sinha, the counsel for the petitioner. As he is unwell, full stop. Matter stands adjourned today. List after a week.
Others, ইয়াত এটা election petition আছে, election petition 1/2021 আৰু hello. 435 তার নাম আছে রয় ডিকে রয় সো দুটো নাম ডিকে রয় তার মানে ভিতৰৰ পৰা দিয়া নাই না ও আচ্ছা আমি শনিবাৰে বিচাৰিছো hello আচ্ছা আচ্ছা এইটো লাইভ কি চলি আছে
This is a review preferred by the state, my lord, against the judgment and order 13/8/2020 and 9/9/2020, my lord. The direction was issued to payment of salary. In earlier occasion, my lord was pleased to deal with similar issues in another reviews preferred by the state, my lord. Sikha Das Gupta. Here also the issue is same, my lord.
No, but you see, despite everything, we'll have to dismiss your petition because there's a order of the proceedings of Lavazima Court that in spite of repeated directions of the Lavazima Court dated 22/5/2019, 7/12/2022, the petitioner failed to take steps for issuance of notice upon the respondent numbers 1, 2, 3, and 8 by registered post, as well as by Dasti. So therefore, matter was listed before the court. And thereafter, 3 dates have passed, but I did not find any prayer to you to take steps. So if you're not taking steps, we'll dismiss it.
In fact, this is my fault, Madam. I have not checked up the record.
No, don't, every time, don't take up the responsibility. Because you see, please try to understand, this is a review petition of 18.
Yes, Madam.
You don't take steps. After 5 years, why should we entertain a review application? It will be hopelessly delayed. And moreover, secondly, you see this order under review
Yes, Madam.
is an order of 2010.
Yes, Madam.
Would it be appropriate to entertain a review at this stage after 13 years? If I ask this question to myself, the answer would be no. Because your explanation for delay is not there.
Yeah, yes, Madam. That explanation is not there, but the reason is that, Madam, basically this person will consider them as illegal appointee, Madam, of 1989. Then, my lord,
No,
they-
Mr. Khatania,
they are
then
subjected
there's a,
to it.
then there's a second question. You see, number one, we understand if you take a plea that there was a fraud, but that plea you are not taking. Because once you allege that there is a fraud, then you would have to proceed against your own officers, though you did not want to do it.
Yes, Madam.
So if there is no fraud, how can the appointment be illegal?
Because, my lord, their appointment against, my lord, non-sanctioned post. Evidently, that is there, my lord. And initially, my lord, they were appointed by DI of schools without the post. And that's why, my lord, we cannot pay the salary.
But you did not proceed against them. The
Yes.
officers you are protecting.
Yes, yes. That is there, my lord. That I cannot deny, my lord.
And the second part is that Mr. Sharma. You see, the second point is that in this review petition, although you have said that you had taken steps for re-verification,
Yes.
there was an exercise undertaken. In fact, for that, 2 matters are listed right now. After you finish,
Yes, yes.
2 matters will be taken up. You see, on record, there is no document to show that in the screening committee, their files were in fact gone into. The corollary is that your stand is that you gave notices to all
Yes.
the teachers. But there's nothing on record that those show cause notices issued to the teachers were brought to its logical conclusion.
Yes, well, subsequently, my lord, may point out the one thing, my lord, how the screening process was started. And
No, it's okay. But after the screening process,
Yes.
it culminated into your own action. You see, there was a report available with you.
yes,
Screening committee report says that XYZ are illegal.
yes,
Correct. You don't go by that report. Now you say that now you take a decision
yes, my lord.
saying that individual show cause notices were issued. So therefore, that screening committee adjudication is merely a point to be taken into consideration. But that can't make it illegal unless the show cause notices are brought to its logical conclusion.
In fact, my lord, what we have done, my lord, we have taken a decision, cabinet took a decision, my lord, to accommodate them also, my lord. Subsequently, in prospectively, a decision was taken And subsequently, most of the petitioners, my lord, here also, my lord, 3 or 4 of them were accommodated as tutor, my lord.
No, that's
Perspective.
okay. There's no dispute with that. But you see, everything must be brought in to its logical conclusion in the manner which is envisaged. When you issue a show cause notice, then at one point you can't say that no, that show cause notices we have done away with. If you had taken a decision on the basis of the screening committee report, you have done it. But the whoever interferes, whether it be a cabinet or it be the government in its own wisdom, they are interfering with it. But what happened to those show cause notices? It was never brought to the logical conclusion as per the record available here.
Yes.
So that is the second point. The third point is that insofar as the state is concerned, you come here and you see this. This para 20.
Yes, my lord. Yes, my lord.
In para 20, you say that now you are in a dilemma as to whether illegal teachers has to be paid or not. That doesn't constitute a ground of a review.
That's okay, my lord.
Then you have no option but to dismiss this.
That is, yeah, my lord. I have seen earlier also, my lord was pleased to point out this
Acha.
regarding this dilemma, my lord. In another review petition also, that same stand was taken by the department.
Because
A
the
dilemma cannot be a ground for review, my lord.
not only that, there is another point which is there. You see, for the purpose of review, there are 3 parameters. You know that.
Yes, my lord. Our only ground is, my lord, the genuine ground that, my lord, we have taken in this review, that this in the meantime, my lord, there was a screening process, my lord, and they have participated in the screening process. And after
that is a subsequent event. You'll have to
Yes, well,
test in appeal.
that is a subsequent event.
The subsequent event, which took place 8 years after the order of the court.
It started in 2012, my lord.
No, whenever it starts. If I put my child in class nursery today, after 10 years, he'll do his metric.
Yes, my lord.
But then that can be a ground to have a challenge. 13 years is too long a time. So these 4 or 5 points which I have flagged, if you have any submission to make,
No, my
then
lord.
we'll enter in, otherwise we'll dismiss it.
No, my lord.
Then I'll dismiss it. I'll record your.
Our ground is, my lord, this regarding the screening process, my lord.
Yes, I'm aware of this.
That is the ground we have basically urged in this review petition, my lord. And subsequent to that, my lord, 4 of the opposite parties, my lord, they have been accommodated as tutor.
Give those names. I'll exclude them from consideration.
Yes, well, I Except opposite parties number 5, my lord, all were accommodated as tutor. She could not be
All were accommodated.
yes, my lord, all were accommodated. She could not be accommodated because my lord, she has already attained the age of superannuation, my lord. While we have taken the decision to accommodate them with prospective effect, my lord, before that, she has attained the age of superannuation, my lord. That's why she could not be accommodated.
Okay. Just. Okay. So this will be your case where normally we say the operation successful, petition, what you call patient died. Here it will be petitioner died. No, sorry, patient died and operation is successful.
Yes, my lord.
Okay, so otherwise you got a relief.
Yes, my lord.
Okay, but I'll dispose it off. I'll dismiss it, but I'll record your submissions about respondent number 5
Yes,
couldn't be accommodated because she had attained the age of superannuation,
yes, my lord.
and others were accommodated
Yes,
as
ma'am.
tutors.
Yes, tutors.
Okay. You have any order number for that? Whether it's accommodating as tutors?
Order, yes, my lord. I'll provide, my lord.
Huh.
I'll get a printout, my lord, and I'll provide.
Okay.
Obliged, lordship.
Yes. Secondary division, you got the information.
Mr. Assembly Trustee is supposed to appear. He's on legs, my lord. There's a judgment being given in court number 3.
Okay,
So he requested, my lord, can be taken up after some time.
okay. Yes.
60.
Lordship, here we've got our instructions in it.
May I please, your lordship? My lord, I have obtained some instruction from the petitioners, my lord. Out of, my lord, my lord, 167 numbers of petitioners, my lord, 21 has already been accommodated as a tutors, my lord.
160,
Out of 167 numbers of petitioners in this petition, my lord,
yes.
21 has already been accommodated as a tutors against their respective schools, my lord.
Yes.
And I have also prepared a list, my lord, against the petitioner number and the schools, my lord. And secondly, my lord, for the rest of the petitioners, my lord, neither the result nor the fate that what will happen to them, my lord, has not yet taken. My lord.
That information I can provide, my lord. With my lord, give me some time, my lord, I will provide. Regarding their status of their application, my lord, after the screening process.
Okay, give a date when we can take it up.
My lord, after 10 days.
Give a date, we'll
Yes.
fix it on that same
Yes,
day
yes, madam.
you want. But see that instructions do come.
Yes, yes, my lord. I'll make it
They are
sure, my lord.
supposed to file an affidavit, my lord. If they are
Better
We'll see,
I'll
because
put it on record, my lord.
if it's bought on record, then we'll give you a copy.
Yes, ma'am. I'll file an affidavit. I'll put it on record, my lord. On 22nd, my lord.
22nd May, okay. Mr. A.R. Bhuyal, and the counsel for the petitioners, has submitted that he has received instructions from the petitioners
Fine.
to the effect that out of
One.
167 petitioners,
My lord.
comma, 21 petitioners have been accommodated as tutors.
Tutors.
He submitted he has the list of such tutors. Full stop. Mr. A. Fukan Lagan, standing also for the Elementary Education Department. Prays for and is granted time to bring on record the status of the petitioners pursuant to the screening process. Acha, sorry, Mr. Anjay Khatun here. First of all, accordingly, it is provided that the instructions received from the Elementary Education Department may either be filed by way of an affidavit or a copy thereof be provided to the learned counsel for the petitioner and so that same can be made a part of record. List on 22/5/2023. So I've given you both options.
My lord, there are two connected petition, my lord. One has been come up, that may also be come up along with that, my lord. Last occasion, both were listed, WPC 8834 2019. my lord.
Please repeat it again. Repeat it again.
WPC 8834 of 2019. my lord.
Okay. List along with.
Obliged.
What is this?
Same, my lord, item 61. my lord.
Same thing? This is same instructions?
No, this is for item 60. Where one out of 167, 146 were not recommended, whereas 21 petitioners were recommended.
Recommended.
And my lord, the list is over here. We'll bring it in the form of an affidavit.
This is item 60,
60.
60.
60.
Watch.
Obliged.
Instructions produced. The instructions dated 2/5/2023 produced by the Learned Standing Council for the Elementary Education Department is kept a part of record. Yes, Mr. Ahmed.
61. 61 is similar matter, my lord. Maybe 1622.
Okay. In view of the order passed today in the connected WPC 8478 of 2019, list this matter on 22/5/2023. Here also do the same thing.
Got same thing. BTC is involved.
BTC is involved.
I pay for 4,506.
Okay.
Same is issuing involved. Only.
No.
Screening committee is involved.
No, that is okay. But
The name has not been recommended, page number 94.
no, but Mr. Bora,
Not sir.
if the matter comes on 22nd before this bench,
Not sir.
then without an affidavit, I am not going to hear you.
In the meantime, I'll file mine.
Affidavit, even anybody respondent should be bottom record. It is 2 days prior to the next date of listing.
Okay.
62. Wait, please, your lordship.
You want the records?
I have gone through my.
Okay.
Yes, lordship.
Yes.
In the last occasion, your lordship asked me to get some orders of the last 2-3 dates, your lordship.
Yes,
got
yes,
it
I
on fourth,
remember.
your lordship. I have the orders with me.
They are from January, my lord is not updated record.
It's okay. That's why I will asked you.
Yes.
So Hussein, where is our previous order?
Your lordship will find the previous order. on
Page
Page
30.
20 is your lordship. Your lordship, earlier it was a joint petition, your lordship. This time he has come alone, your lordship. Actually, your lordship, Baidullah Khan was the main accused, your lordship. His name was not even in the FIR, your lordship. Subsequently, his name was in the search sheet, your lordship. And your lordship, FIR number accused Nissan Sharma has been granted bail by the coordinate bench of this court, your lordship. And another search.
Where is that?
Your lordship will find that order on page 50, your lordship. Is 50, your lordship. Initially, your lordship, there were 3 FIR name accused. Nissan Sharma was one of them, your lordship. His name was finally entered in a search sheet also, your lordship. And another, your lordship, accused, your lordship, whose name entered in the search sheet. Subsequently, your lordship, he was being granted bail by the additional session judge court, your lordship. That also order also I have furnished, your lordship.
Now, this is an application for whom?
Your lordship, Samsullah Khan.
Samsullah
Khan.
Khan.
Your lordship.
Just a moment, just a moment.
Lordship.
You are arrested when?
Your lordship, I was arrested on
7/7/2022.
22, more than 300 days, your lordship, behind the bar.
Mr. Goswami will have to grant him bail
Lordship,
because of this 300 days, about 300 days and the charge has not been explained to him.
Lordship, the last orders I have not gone through, my lord, regarding that, my lord.
No, I have the certified copy of the orders.
Lordship,
The last order is about of 24/4/2023,
Lordship,
fixing the matter on 4/5/2023 for further hearing on the question of charge.
yes. The charge is not yet framed, my lord. So let the charge be framed, my lord, as in the next.
No, he can always appear. If all other accused have been granted bail.
That is one part, my lord. Otherwise, my lord, regarding the merit, my lord,
Yes.
I rely on your lordship's page 30, lordship, para 6, lordship, where your lordship has indicated the involvement of the petitioner on the earlier occasion of time, my lord, regarding his, along with the co-accused, my lord, para 6, my lord.
No, now we can always give a condition.
Plus. And my lord, secondly, my lord, the criminal and antecedent, my lord, regarding my lord. I have found, my lord, he has some other cases also pending, and these are also serious cases, my lord.
Where is
So
that?
it is, that is, my lord. I
Where is
have,
that?
In the record, my lord, in the last portion of the record, my lord. So there is every possibility, my lord, that we may influence the witnesses, my lord. We trade, my lord. And the Google PS4, the last portion, my lord, in the site flag, my lord. This case is also, my lord, my humble submission, they are serious sections.
As per charge sheet, what is the allegations against him?
Your lordship will find a search sheet on page
Uh,
17 to 27.
Explain, my lord, I have.
Page 27, your lordship.
Just a moment.
Yes.
Page 20.
In page 27, your lordship will find the
Search
relevant
sheet,
page.
my lord, I have flag mark, my lord.
Twenty-six.
Same thing which I've been telling you.
Lordship, I understand. Regarding the matter. Yes. That is what I am reading, my lord, that came to my mind also, my lord. Lordship, square will be there, my lord.
I think we'll have to give,
Uh,
despite, we'll put some stringent conditions, but it has to be given.
And also rely on my lord regarding the September until Kumar's judgment, my lord. Where my period of 1 year may not be, my lord, against the Article 21 of the Constitution of India, my lord. Regarding that.
Heard. Mr. M.I. Hussain, Learned Counsel for the, sorry, I Hussain, Learned Counsel for the petitioner, as well as Mr. M.B. Goswami, Learned AVP for the state. Next paragraph. The previous prayer for bail was rejected by this court by order dated 9/2/2023, passed in BA 3679 of 2022. And this is the, and therefore, this is the second bail application of the petitioner. In connection with Dibrugarh PS case number 390 of 2022. Under section 306/34 IPC. Added with added sections 120B of 307 IPC. Comma, which is presently being tried as sessions case number 349 of 2022. Next one. The learned counsel for the petitioner has submitted that the petitioner was arrested on 7/7/2022 and has been in custody for the last
304 days.
4 days. Poster. The scan copy of the order sheet up to 5/1/2022 is already available. And the learned counsel for the petitioner has produced the certified copy of order dated 22/3/2023. PO2. (24/4/2023). Post- The no, not project, comma. Project that the case was last fixed on 4/5/2023 for hearing on the question of charge. First of all, what happened on 4? You are
No,
aware?
so
No.
four also nothing happened, your lordship. Again, I have heard another date has been fixed, your lordship.
Okay, the learned counsel for the petitioner also summarized that as per verbal instructions received by him, comma, the charges were not framed on 4/5/2023. Next paragraph. The scanned copy of the case records received from the case record of sessions case number 349 of 2022 was available with the records of BA 3679 of 2022. The learned APP has perused the same and has opposed the prayer for bail. By submitting that the petitioner is involved in the threatening given to the deceased who out of fear had committed suicide, was driven to suicide. First off, it is also submitted that the case diary also contains materials to show that the petitioner is a habitual offender and he is involved in another case being Dibrugarh PS case number 418 of 2022 under section 341/387/294/506/34 IPC, read with section 14 within bracket small z bracket close of Assam Microfinance Institution within bracket regulation of money lending bracket close Act, 2020. Read with section 19 within bracket small d bracket close of the transplantation of the human organs and Tissues Act 1994. This 418 is a related case, I believe.
But the sections are different, madam. The present case is, my lord, 300.
90 or 22.
Yes, your lordship.
And this is 408 or 22. It appears to be same. P87 putting fear to death.
Yeah.
So if he was already arrested in 418.
Yes.
Oh, sorry, in this 390.
390, madam.
How can this 418 be registered against him?
Because it is subsequently registered, madam.
Can you get us a photocopy of the charge sheet? Sorry, the FIR.
I have just found from, just found from the.
No, I understand, but can you get it
Yes,
by tomorrow, day after tomorrow? Then we take a day after tomorrow.
lordship. Yes.
Because this, if 418 is correct, then you are also accused of threatening someone with death.
Your Lordship, I am not for this case, Your Lordship. I am for this.
No, I understand. But if the same incident, you have been, what you call, repeated offender. If this is a different case and you have threatened somebody for recovery of money by putting him to fear of death, then that has to be considered. Because this Microfinance Act has been added. That means for money you are threatening someone.
Condition for bail, madam.
Just get us this.
Lordship.
Just omit all those part. You say Mr. I Hussain is considered the petitioner present. Mr. MP Goswami and DPP has referred to the case diary and had submitted that the petitioner appears to be a repeat offender, as there is also another case being Dibrugarh PS case number 418 of 2022. It was registered on section 341, 387, so and so, read with so and so. There are two offenses. Next, accordingly, the land AVP prays for and is granted time to produce the photocopy of the FIR. Which is registered as Dibrugarh PS case number 418 of 2022. We listed on Thursday. Is it possible for you to get it?
Thursday or Friday, well, I will try.
Okay.
If your lordship's convenience, madam.
No, it's okay. For me, it is convenient every day. 12:05 then. Mr. Hussain,
Lordship.
please. Please keep this with you. We'll produce on the next date.
Maybe, madam, permitted to take a downloaded copy for order, madam. A copy of, madam, I will.
Yes.
A
The
downloaded copy of
AVP shall send a downloaded copy of this order to the officer in charge of Dibrugarh police station, unable to obtain the same, the copy of FIR in Dibrugarh PS case number 418 of 2022.
Lost.
List functions.
And I was by for violation of an order. Page 29.
Let's take up the IA, my lord.
Yes.
IA, my lord, please.
Lordship, may I read the last portion?
Just a moment. Yes. Everybody is not filed here.
Fine, my lord. Primary with the finance department, my lordship will take the IA, my lord. IA, he is challenging Alexa
No,
B, my lord.
we'll hear Mr. Bora first, then we'll come to you.
Sometime to file affidavit for the BTC part, my lord. Basically, he is harping on the not to give sanction by the finance department. This particular post.
No, in this, I is asking for the stay of the notification of 9 to
Yes.
2021.
Yes, my lord. And they're involved in the post of 1009, and these persons had already been appointed. And and multiple expeditions are pending till today, my lord. Pursuant to a division bench order, this persons have been, all this 900 person have been appointed.
This 1009 people have been appointed.
Got already appointment, and there are large numbers of writ petition, a series of writ petition are pending for area salary and everything.
But Mr. Bora, we find it you see, this is a sort of an injunction application. You're making an oral submission. You're not filing an affidavit.
No, I'll file my affidavit sometime maybe when.
No, we are giving you time and again, but since,
It's a new one, my lord.
no, this is a 2021 application. Notice was issued on 29/7/22.
So I'm waiting for the instruction, my lord.
No, you see, you can't frustrate the prayer of the petitioner by just praying for adjournment without any intention to oppose this application. If you are not opposing it for 9 months, 10 months, is there any surety that you will oppose it now?
Now, my lord, because the lordship will put along with the other cases, my lord, because there are cases-
No. What is the application before me? It's okay. If you are trying to say that there are other matters which are connected, without your affidavit, we are not taking your oral submission and
Lordship allow me 10 days to file my affidavit.
That is not connected.
no, whether it is there or not, I don't know. But unless the respondent comes and says that they are
Lordship,
connected,
then my lord, I'll file my affidavit. But
by what time?
10 days lordship will come, on 10 days.
But I'm making it clear that if you don't file it, then we ask your BTC authorities to be personally present
My lord, lordship
to
will,
answer the.
I'll, within 10 days I'll file.
No, it's okay, but I'm making it clear that if you don't file it, then your authorities will be here in
Sure.
court.
Lordship,
Which is a-
page 29, it is very clear order. Until further order of this code, the respondent authorities shall not fill up 1870 vacancies of lower primary and upper primary school in BTC area. That is the direction of the code. Now, they were present at the time of hearing. In violation of this order, they have now filled up the post. That cannot
That is
be an
different,
excuse.
Lordship.
No, it's okay. But you see, once the post is filled up, we'll have to hear it and then undo it.
Yes.
By an interim order, we can't prevent the persons already appointed to be out.
Yes, Lord.
You
Let
see,
them come up with an affidavit.
that's what you're saying. You see, Mr. Bora,
Lordship.
please try to understand or make me understand either of two. Number one, this is an interlocutory application for stay.
Yes.
This is not an application for violation of the order of the court.
Yes, yes.
That is number one. Number two is that somebody have been appointed by virtue of an order, whether illegally or not, we are not on it now.
Yes.
But once an appointment is made by an interim order, we can't undo it. We can't, you see, this, the power to undo it will be not available. Because those people will have to be heard now.
Yes, that is correct, Lordship, but that precise issue was being pleaded in this case, Lordship, that they do not have the qualification and they were seeking to appoint. Therefore, this interim order was passed. In violation of this interim order, they have now issued that order of filling up.
No, there's no
When it
difficulty.
was
There's no
pending,
difficulty.
now they have appointed.
Mr. Bora, there is no difficulty in understanding that. But this is the twofold query I have. You see, we are not hearing you on the violation application.
Yes,
Correct? It's a stay application.
yes,
So we have a limited contour.
yes,
We can't travel beyond a particular limit.
yes.
So in that view of the matter, I can't pass an order which will put these people on the streets. Because these appointments will have to be challenged or declared to be illegal. I don't know whether in interlocutory,
Before appointment, I had filed the I.
that is okay.
That is, they are.
That is okay. But that's what I'm asking you. The query is that once they have done it, this order has to be put to challenge. Either you have to amend your writ petition, or you take whatever recourse you want to do, but in an interlocutory application, how far we can go and adjudicate? Because the prayer is simple, a prayer for stay. The parties have already, somebody who were affected by this order have already joined.
Yes, sir.
So you tell us what is the power under that circumstances?
Lordship, this is a 226 application. Therefore, Lordship will see my prayer for once. Whether my prayer in the petition still survives or not. Lordship, that is the question.
No, definitely, you see, Mr. Bora, I leave it to you. It is your writ petition.
Yeah.
In your interlocutory application, am I permitted to say that the prayer made in the writ petition has become infructuous?
No, Lord, no.
So that is why you see, that's why I'm posing that question to you.
Yeah, Lordship, I'll satisfy, let them file their affidavit.
Because you understand the
Yeah,
limitations.
yes, Lordship, I can.
Had it been a violation, it would be a different matter altogether. Had it been a challenge to this petition, it would be a different matter. Because you have to also make me understand the power which I have. But Mr. BP Boral and the counsel for the petitioner, for the applicants. He has pointed out that despite the order of this court dated, where is that?
29 page 29.
8/5/2019. 1009.
1009, 1009.
1009. 1009. 1009. Persons have been appointed in the as teachers in vacancies arising in lower and upper primary schools in BTC area. Stop. Mr. As Borat and standing counsel for the BTC is present and prays for 10 days time to file affidavit in opposition in the matter. Mr. Nayak, you are for?
Finance department. Finance.
Yes, sir. Mr. P. Nayak and the standing counsel for the finance department is present. Next paragraph. The respondents in the BTC are put to notice that notice in this application was issued by order dated 29/7/2022. So accordingly, it is provided that in the event an affidavit in opposition in this matter is not filed at least 2 days prior to the date of listing, comma, the following authorities, namely number one, the principal secretary BTC within bracket respond number 2, comma, secretary BTC within bracket respond number 3, comma, joint secretary BTC within bracket respond number 8, additional principal secretary BTC within bracket respond number 9, director of education BTC within bracket respond number 10 shall all be personally present with all relevant records and be prepared to assist their learned standing counsel to respond to the court queries. You said 10 days time. Today is 8th. 10 days will be 17.
Let it be on 19th, my lord.
So we're fixing it on 19th.
Yes.
Correct?
Yes.
List on 19/5/2023. Next, by the learned standing counsel for the BTC shall transmit a downloaded copy of this order to the respondents and shall produce a proof of such transmission to the court on the next date.
If you,
39 lawsuits. And it's a week time lawsuit. I have already had a consultation with the secretary lawsuit. Just, I have already informed them also lawsuit that any week time lawsuit can be given.
Which time?
39.
Okay. Mr. S.K. Goswami, Learned Counsel for the petition is present. Mr. S.M.T. Chisti, Learned Standing Counsel for the elementary education,
It is from secondary.
the secondary education. Raised for a week's time to obtain updated instructions. Here is allowed. List on 19/5/2023.
Yes. Oblige you.
Mr. Just a moment. Mr. Chisti, I make an observation here that pendency would not be a bar to you to
Yeah,
read
that
this.
can be given. Yes, yes.
The pendency of this contempt petition shall not be a bar for the respondent authorities to comply with the order of the court.
Yes. Oblige.
Part 2 hearing list item number 60.
Well, I have made a small written argument, my lord. Basically, they want to say, my lord, by the 24/12/1998 circular, they have brought in the requirement. If that be so, to give effect to that, they issued the circular for the first time on 13/1/2000. I love to kindly have the written argument. So, Lordship would kindly come to page 4. The basic case
Just-
projected in the written.
Just a moment. Mr.
I'm sorry.
No. I've been wearing the belt for the entire day. I'm now feeling uncomfortable.
And in summer, these are really wonderful. Winter, one can appreciate.
Yes, I have. If I'm wearing it for long, I'm sitting it for long, I'm compelled to wear it. Can't help it. Risk of trade.
Page 4, my lord.
Yes.
The basic case projected in the repetition is that there was no requirement of net slate in the advertisement dated 6/6/98. The selection process thereafter concluded on 4/12/98 when selection committee gave first nomination to the petitioner. The use of the phrase present UGC norms in the advertisement is very significant. There is no dispute that on the advertisement dated, that is on the date of the advertisement, that is 6/6/98, or on the last date of receipt of so and so, that is 21/6/98, there is no prescription by UGC mandating requirement of net slate by the incumbent desirous of becoming a lecturer in the college. Therefore, final approval order dated 15/6/06, which mandates such requirement, is expressly arbitrary and without any statutory sanction. Under entry 66 of list 1 of the 7th schedule, it is prerogative of the Union UGC to lay down norms for maintenance of standards in institution for higher education. The UGC notification dated 24/12/98, which prescribed minimum qualification for appointment of teachers in universities and colleges, for the first time prescribed requirement of net slate. Pertinently, the instant selection process concluded on 4/12/98, months before issuance of circular dated 24/12/98. Therefore, question of retrospectively applying a requirement envisaged by the UGC circular dated 24/12/98 does not arise. In this regard, petitioner seeks to refer and rely upon following judgment, which inter alia provides that rules, norms prevailing on the date of advertisement would govern the selection. That following UGC circular dated 24/12/98, the government of Assam via OM dated 13/1/2000 decided to implement the norms laid down by UGC. Thus, effectively, the state government decided to insist upon requirement of having net slate from 13/1/2000, which is post the advertisement dated 6/6/98. That the delay in approval of the petitioner's selection is on account of factors attributable to respondents, and the petitioners cannot be held responsible for the same. Admitted position is that selection process commenced on 6/6/98 when norms prescribed by UGC did not require net slate. In that view of the matter, condition in the final approval order dated 15/6/06 lacks statutory sanction, and under the circumstances, it has to be construed as an arbitrary imposition. Now, this paragraph is important, my lord, because in the affidavit they say something. Pertinently, in the affidavit dated 12/5/17 filed by respondent number 3, at paragraph 7 admitted the aforesaid fact that state government via OM dated 13/1/2000 made possession of net slate mandatory. Averment in the said paragraph that as per UGC norms which are mandatory in nature, those who joined in service after 24/12/98 is mandatorily required to have cleared net slate is wholly misconceived. What can be logically argued is that any selection taking place after 24/12/98 can prescribe requirement of net slate. That being the admitted position, stand of the respondent number 3 appears to be unreasonable and untenable. But this is the case, madam. Now they said, if anybody joining after 24/12 must have netted. Where from this joining word comes, madam? In the advertisement, they use the expression present UGC norms. Present UGC norms did not include this, my lord. I don't think it's in a sense, my lord, respectfully, Elsa is an open and shut case, my lord. It's not that there is any other. So all that I'm asking for is, my lord, my salary from the day one should be given. Instead of putting me on probation, I should have been straight away appointed. My lord, this Mr. That
Gogoi.
No, my lord. Prior to what is 1 second?
Oh, the director.
Ah,
I took note of that.
a lot of my lord.
I took a note of that submission. That he was sitting over your file for 3 years.
File, yes.
This is-
What was my fault? I was selected in 98. So for no reason, my lord, the second nominee was sought to be appointed. Then, my lord, he was sitting from 2003 to 2006. Only when I instituted a contempt proceeding, that
Yeah,
day, my lord.
yes.
Yes.
I took a note of that specifically.
Therefore, my humble submission is, my lord. In fact, my lord, I feel sorry for this petitioner, my lord. Kindly see, my lord, as her compatriots are drawing salary of 1 lakh plus, he is getting 8,000. And kindly see from the year, my lord. She had joined in 2006 and now we're in 17 years. My lord, it's a case of a mental agony, my lord. In fact, my lord, the director in 15, after she completed net slate, if the government is so conscious with the right of citizens, at least from 2013, when she cleared, she should have been paid. That also till that they have not done. That I'm not conceding. Well, I say at least to show their bona fide, they could have come up. Because the director wrote, the successor director wrote. He said there was no requirement of net slate in the advertisement. The appointment was delayed because second nominee was sought to be appointed.
Only have to consider that argument about that notifications, which
Yes,
is given.
that is the notification, my lord. I have dealt with that, my lord.
No, it's okay.
Yes.
That's the only thing I have to consider.
Yes. I'm deeply obliged.
Thank
you. Well, there is one item in code number. Can I take?
Please.
My junior.
No, I'll close it and I'll
Yes, yes.
pass orders.
Yes.
After that. You just give your name. Your name I always forget.
Okay.
Just write it to the court master.
Absolutely.
It's item number 1, 2, 3, 4. Here you write the argument in connected. In a similar matter being WPC 579 of 2016 has been concluded. List on date Friday, list on Friday will be 12 for delivery of orders. This is item 1, 2, 3, 4. List on sales for delivery orders. Here also you write in this item 60 part 2. Mr. K. N. Chaudhary, senior counsel for the petitioner. His reply argument is concluded, assisted by
And Mahanta.
Ms. N. Mahanta, counsel for the petitioner. Reply argument is concluded. And a written note of submissions has been filed. Mr. S. Das, standing counsel for the Higher Education Department is present. This same Friday for delivery of orders.
Keep you next.
Part 2 hearing list.
Anyone is present for part 2?
Five zero seven. Oh.
ভগাই দিছে হা?
ইমান বাঁকা আছে এটা লগা নাই এনেই আছে তাতে ক'ত লগাম তাতে ইমান বাঁকা আছে আগৰ এইবিলাক কি দিছে যিবিলাক দিছে এটাও ফুটা কৰা নাই সেইকাৰণে এনে ৰাখিম কালি যদি ঘূৰি আহিম তেতিয়া চিনি কৰি ৰাখিম ভিতৰত ভৰাই দিছে ভৰাই দিছো তাতে আগৰ বিলাক এটাও লগা এইটো লাগিব আৰু সেইটো চাই তুমি লগাই দিবা লাগছিল তোমাৰ লগাই দিবা হ'ল কওক আচ্ছা আচ্ছা yes sir